All rise. Court of Appeal and for the 5th District of the State of Florida is now in session. The Honorable Carrie I. Evander, Judge, presiding. All persons having business before the court, draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Okay, good morning, and welcome to a session of oral arguments for the 5th DCA. I'm going to go ahead and introduce the rest of the panel to you. Sitting on my right is Judge Jay Cohen. He was, before joining the 5th, a circuit judge in Orange County. Sitting to my left, we're pleased to have sitting as associate judge with us today, Judge Donna McIntosh, who's currently a circuit judge in Seminole County. We have 3 cases scheduled for argument today. The first 2 are criminal. Each side will have 15 minutes. And then the third case is civil, and each side will have 20 minutes. When you come up here, tell me how much time you want to set aside for rebuttal. I'll try to help you keep track of that time. In addition, if you have a cell phone on, if you make sure it's off so we don't interrupt the oral arguments. And between the second and third oral argument, we'll take a break, and any attorneys that would like to join us, we will do so in the attorney's lounge. Okay, the first case then will be Green versus State. And Ms. Fryer, how much time would you like for rebuttal?
3 minutes, please, Your Honor.
Okay.
Good morning. Good morning. May it please the court. Because of the limited time that I have here today, I'd like to primarily focus on 2 issues, with one being dominant. I'd like to focus on the erroneous jury instruction as to causation in this matter. And secondary, I'd like to focus on the Williams Rule evidence that was erroneously submitted. If the court has any other questions on any other matters, I'd be happy to address those as well. Your Honor, the jury instructions on causations were confusing as to the point of being misleading in this matter. The facts in this particular case are that Mr. Green was convicted of second-degree murder. The cause of death of Dwayne Hurt.
We're familiar with the facts.
Okay. In this matter, then, the court's familiar with the fact that the state requested jury instructions on causation based on the Eversley case. In the Eversley case, they used a but-for analysis. The instruction that was requested by the state was also based on this but-for analysis. Defense objected and submitted her own instructions in this matter, and ultimately the trial court crafted her own instructions and based those on Eversley as a template. In Eversley, the Florida Supreme Court...
Before we get to Eversley, let me ask you about the preservation issue.
Yes.
Okay, it's my understanding the state propounded a proposed instruction. Y'all objected as to the second paragraph of the instruction on the grounds that you didn't think it emphasized the burden of proof of the state sufficiently. And then the judge said, I'll take this home and work on it tonight. And then the judge came back and changed the second paragraph, correct?
Correct.
And arguably made it a little stronger as to reinforce the state had the burden of proof. Okay, at that time, you know, the objection seems to be none that is previously noted. I mean, is that sufficient to preserve your objection?
I'll be frank, I think it's imperfect at best. I think the objection itself was fairly ambiguous. And I think it almost had to be because the instruction was so esoteric.
But I don't know what you mean by imperfect. I mean, either it's preserved by objection or it isn't preserved by objection. How would that preserve the issue? The instruction is changed and an opportunity is given to object to it, and the only thing said is, well, nothing other than what we already said, which had been addressed by the court. So how is that preserved?
If I'm not mistaken, Your Honor, the objection itself was a bit long-winded. So there was an issue with the burden of proof of the state. There was also an issue with changing the element of the crime itself, that adding this instruction would change the elements of second-degree murder in this matter. So I'm asserting that even though it was a long string of objections there when she renewed those objections at trial. That issue, changing the elements, I think is still material and still stands.
All right, as opposed to the burden of proof,
Correct.
all right?
Okay. In the Eversley decision, the Florida Supreme Court visited the issue of causation. The Florida Supreme Court directed this toward what the court should do, the type of analysis that court should deal in. They pointed to legal scholars who examined these very complex issues. They talked in broad terms about initially this cause and fact and the proximate cause. The very first determination they made is whether it was going to be this but-for analysis or whether it was going to be
The issue of causation is presented to the jury. The defense in this case presented that argument to the jury. Did they not?
They did, Your Honor.
Argued that, among other things, other than, the insufficiency of the evidence, but they also argued the causation issue to the jury.
That's correct, Your Honor.
And is the jury not entitled to some direction in terms of the instruction on law?
Your Honor, I would submit that the way that the jury was instructed on this was hopelessly confusing. I would submit, based on the prosecutor's argument himself, that he had a difficult time distinguishing between substantial factor and but-for analysis. He conflated those two very different legal doctrine, explained that he used terms like, he may not be the but-for, he may be a but-for.
The prosecutor's argument isn't law and isn't what the jury was told to follow. The jury was given legal instructions, and is it your position that the legal instruction given was incorrect in terms of what you're saying now is the elements of the offense?
Yes, Your Honor. Let me rephrase. The jury was given the proper state of the law, but they were given law that was never meant to be a jury instruction. The questions that they were, the ends that they were given, the task that they were given, was one that became nearly impossible with functional facts to deal with. Issues like, was this just and fair, beyond the scope of any fair assessment? And then just what is typically the most simple part of the law school examination, which is the but-for, the substantial factor. The prosecutor himself was unable to distinguish what exactly that meant. Based on the pure instructions here, this but-for analysis that was submitted to the jury, it was erroneous to argue and try to explain this to the jury that the substantial factor test would be enough. He asked for a very specific instruction, the court gave it, but ultimately there was this idea that if there was some minor participation, that's enough. That's not the but-for test. And I submit that it's so confusing that if the prosecutor couldn't get it, and I have to fess up to a mistake or something that I overlooked. In preparing for this last night, I came across something that I either missed or I missed the significance of in the answer brief. And that was on page 18 in the answer brief. I realized that the appellee also conflated the two cause and fact theories. They mentioned that the substantial factor test could be used to get to this end to find causation. But that's not what was submitted to the jury. It was the strict but-for cause. I would also like to point out that the trial court at no point engaged in the analysis about which test would be appropriate, because they're very different. And the Eversley test, that was the initial matter. It was up to the court initially, the district court, then the Florida Supreme Court,
It seems
to
that
get
the
at
failure to
causation.
instruct on the substantial factor test would actually benefit your client, because the state would have two ways to go on the first. One is the but-for test, which might be a little difficult here because there was several people involved in kicking the victim when he was down. So the jury could have found that, gee, even if your client hadn't kicked the victim, he would have had the stroke anyway. Whereas the substantial factor test deals with a situation where you have more than two actors, and it's almost impossible to distinguish who might have given the fatal blow, if you would. And so, to me, the failure to instruct on that would have been beneficial to your client.
That's accurate, but it's our argument that the second-degree murder instructions were sufficient in and of themselves. The causation is in there, and the jury can make their own determination. When this comes up to the District Court of Appeal to determine whether causation was sufficient at the motion for judgment of acquittal, the type of scholarly analysis that the jury was asked to engage in actually occurs here, or up at the Florida Supreme Court, or maybe the judge determines that at their JOA. But to ask a jury to figure out whether they feel that any action was beyond the scope of fair assessment, or if based on fairness and justice,
Isn't that a fact-intensive determination?
It is, but not alone. It's also an analytical determination based on an understanding of legal doctrine. Legal doctrine that even the very bright prosecutor in this case was unable to distinguish. So I submit that the jury was given an almost...
It's called Will J. Very bright. Everybody's campaign committee,
I'll stand silent on that. But I just think it's objective proof that if the prosecutor himself, and then at the appellate level, the state continues to have an issue with these concepts, it was incredibly unfair and a hopeless task to ask the jury to somehow be able to distinguish this better than individuals who've been to law school and had the opportunity to sort these ideas out a long time ago. Based on that, Mr. Green was deprived the right of a fair trial. This action was so attenuated that if we find that somehow the jury instructions were proper and we're going to allow juries to engage in this type of legal analysis instead of this fact-finding issue, then the judgment of acquittal should have been granted. If this is strictly but-for causation, Dr. Utz was very clear about the fact that he couldn't say with certainty which blow caused any damage for Mr. Green. It was impossible, and the prosecutor was very frank in closing, saying that it just had to be a but-for. He couldn't tell you which one caused any particular damage. If the jury instructions were proper, then defense counsel in this case was correct. The evidence was insufficient to find Mr. Green guilty of second-degree murder and also of manslaughter where this instruction existed. It didn't exist in the aggravated battery, so I won't argue that. I simply can't.
Let me ask, on the Williams Rule issue, what was the objection made when the state moved to put in evidence of the prior disagreement, if you would, between your client and the victim's brother?
Certainly. One was Williams Rule. One was, I'm sorry if I may hear. If I'm not mistaken, counsel conceded relevance at that point.
What was the initial objection? Was it relevance?
I apologize, Your Honor.
Okay. All right. You can certainly look at that before you come for rebuttal. Let me ask one other thing. Did both sides mention the prior incident during opening statements? That there have been, not the incident specifically, but there have been prior difficulties, or if you would, between the victim's brother and the defendant?
I'm not certain whether defense mentioned that, and I can't say with any certainty that the state did.
All right, you have a little over 3 minutes.
Okay, I'll reserve and find that portion. Thank you, Your Honor.
May it please the court, my name is Bonnie Parrish. I represent the state of Florida in this case. Would you like me to start with the Williams Rule issue and the objection, or you want me to start with the...
Your choice. You address...
Well, I do have the objection. I do have the objection for the Williams Rule.
Okay.
And it was objection as to the form of the question and objection as to the relevancy of the fight that occurred months before. While I agree that there was a disagreement, or that may be relevant for the state to go into, what they shouldn't be allowed to go into is an uncharged crime for which I wasn't provided Williams Rule notice. At deposition, Mr. Hurd stated that my client punched him when they had this incident months before up in Eustis.
Okay.
That was the objection.
So they did preserve the objection there?
They preserved it as far as the Williams Rule notice, yes. And they have to show prejudice
Would you agree that
Unfair
it was a
surprise.
violation as far as the lack of notice?
It doesn't appear that they gave notice, no, but the defendant clearly knew about it. They knew about it at the deposition, so they weren't
So
surprised.
you agree there was error, but the question is whether it's prejudicial error?
It's harmless error, yes. As to the jury instruction on causation, both sides in this case agreed that causation was an issue. The defendant had proposed jury instructions, the state had a proposed instruction. Based on the arguments, the judge went back and read Eversley and looked at the cases and came up with the instruction that she came up with. There was no objection to that instruction. I would disagree that this instruction changed the elements of the crimes. This instruction let the jury to decide whether the defendant should be held responsible for what occurred. Cause was an issue. And I submit that
When the judge changes the instruction, the defense lawyer says, are there any objections? None other than those which had been previously raised.
correct.
So to the extent that the judge did not alter portions of that jury instruction, why wouldn't that be preserved?
The portion that was altered was the part that they objected to. The judge rephrased that portion of the instruction. She made the instruction have one paragraph with 3 parts as opposed to the way the state had done it with 1 paragraph for the cause and fact, the but for, and then 1 for the proximate cause. She combined the 3 of them and made it very clear that the state had to prove each of those things beyond a reasonable doubt. Personally, it upped the burden on the state, as pointed out by co-counsel, or not co-counsel, the co-defendant's counsel. The state was required to prove beyond a reasonable doubt that it wasn't unfair or unjust to hold him criminally responsible, that the victim's death was not beyond the scope of any fair assessment of danger created by the defendant's criminal act, and then, but for his criminal act, the death wouldn't have occurred. So I believe the instruction that was given in this case was proper. I don't believe it was misleading or confusing. It was a factual issue. What caused the death in this case? Who caused the death in this case? And I believe the instruction was proper. So if there are no further questions, I'll rely on my brief and ask that you affirm the conviction.
All right, thank you.
Thank you, Your Honor. As to the Williams Rule issue, under the Downs case provided and cited in the brief, the erroneous admission of evidence of collateral crimes is presumptively harmful in this matter. In this matter, there was, without the proper analysis by the trial court, she merely found relevancy and then let it proceed on there, introduced evidence of what is essentially a burglary with a battery, a life felony in this matter. So it simply was a bad act. The defense attorney never had the opportunity to get to issues as similarity, or whether it was remote. It certainly wasn't even aimed at Dwayne Hurd, the deceased in this matter. It was several months ago. None of those issues were properly litigated out because it was found to be admissible without proper notice and without the proper analysis in these matters. So that in and of itself is presumptively harmful.
Well, there is no dispute that counsel for the defense was aware of this prior incident, correct?
That's correct. However, it was never properly noticed in terms of whether it was going to be introduced at trial or not.
Motion eliminated to prevent its admission?
No, Your Honor, but I would submit that the burden here is on the state to submit that notice that they're going to be introducing these, to give the opportunity to litigate these issues out pre-trial. There are many issues that counsel's aware of that aren't going to be admissible at trial without proper litigation, and I would submit that this is one of those.
Anything else?
I don't have anything else. If there are no further questions, I would just simply respectfully ask to reverse this conviction and give Mr. Green the opportunity for a fair trial. Thank you so much.
Thank you both.